From LPM,
Louisville Public Media.
Support for LPM podcasts comes from the Eye Care Institute and Butchertown Clinical Trials, where they strive for diversity, equity, and inclusion within their staff, patients, and clinical trial participants. To learn more, visit butchertown.clinic.
Welcome to Race Unwrapped. I'm Michelle Tyreen Johnson. How did a U.S. Supreme Court case from 2013 widen the race gap in voting? We'll find out today from Dr. Kevin Morris. He's a senior research fellow and voting policy scholar with the Democracy Program at the Brennan Center for Justice. He's going to walk us through Shelby County v. Holder and how it undermined the Voting Rights Act. I know you it's brand new, just had a paper that came out about the Supreme Court ruling that you and your colleagues say account for the huge gap in voting between non-whites and white voters. Could you tell me a little bit, first of all, about what the case is and what it symbolizes, what it undid or did?
Yeah, absolutely. So one of the things that we show is that the Supreme Court decision was a big part of the growing turnout gap, but it can't actually explain all of it. That the turnout gap is growing all around the country in progressive and conservative places alike. But in 2013, the Supreme Court handed down a decision in the case was called Shelby County v. Holder, and that really undermined a lot of the strength of the 1965 Voting Rights Act. And we argue that led to an especially big increase in the racial turnout gap. And what Shelby County did is it effectively suspended Section 5 of the Voting Rights Act. And what Section 5 of the Voting Rights Act did is it required states and localities, usually counties, with a history of race discrimination in their voting policies to get permission from the federal government before they could change any of their policies.
It's called pre-clearance, right? Mm-hmm.
Yeah, they had to pre-clear any change with the federal government before it could go into effect. So pre-clearance, in a lot of ways, it flips the script on how law and policy works in the United States. Usually, when a state or federal government passes a bill and creates a new law, it is presumed legal until maybe there's a court challenge against it that tries to overturn a law. But that can take many years. It takes litigation. It takes civil rights groups investing a bunch of resources into overturning a law. Pre-clearance, it kind of did the opposite. It said before it can go into effect, before this law or policy can go into effect, you have to prove that it will not be racially discriminatory. The DOJ under Obama called it one of the most effective civil rights acts of all time. The kind of example that I like to give, that a lot of people give, that really kind of illustrates the way that this worked out in practice is that in 2011, before 2013, before Shelby County was handed down and when pre-clearance was still in effect, Texas passed a restrictive voter ID bill. And because it was covered under the pre-clearance regime, they had to get permission from the federal government before it could go into effect. And the federal government said no. The federal government said this cannot go into effect because it will have racially discriminatory effects. So pre-clearance worked in that case. The same day, June 25th, 2013, that Shelby County was handed down, Texas repassed the exact same voter ID bill. But now, without pre-clearance, we and other civil rights groups have to sue and invest a huge amount of resources in trying to get it overturned. So, these policies that states are doing, knowing that they have racially discriminatory impacts that used to be stopped by the Strong Voting Rights Act, now require a huge amount of resources to get them overturned.
So, if I recall, the Voting Rights Act and pre-clearance, it wasn't something that covered all the states. It was pretty much the states that had a long time, storied history in making sure that, in particular, Black people, even though they've expanded, but that Black people couldn't vote. Is that correct? About what states would that be?
Yeah. I don't have the specific list of states in front of me, but you're exactly right. It's a lot of, frankly, the old Confederacy. So Georgia and Alabama and Mississippi, these states, parts of Florida were covered under it as well. But also other parts of the country. So New York City was covered under it because of discrimination against linguistic minorities. That, especially in parts of the city like Queens, where there are tons of immigrants and naturalized citizens that speak all kinds of different languages, the city wasn't doing a good job of providing those folks with materials in a language that they could speak. So yes, definitely, and kind of a lot of the scholarship on it points to really focused on areas with long histories of anti-blackness in their election policies. But there were other parts of the country that were covered as well. Texas, of course, has a long history of anti-blackness, but the kind of Latino politics as well gets filtered into this too.
Right. I lived in Austin, which is probably the blue dot, in the middle of Texas, and it was interesting as a Black Midwesterner to go someplace where I was not the targeted minority. Like it was uncomfortable and yet very fascinating to observe people all but saying, well, you're Black, not Latino, so we dislike you a little bit less than we like Latinos. I mean, did anybody actually say that to me? No. Was it sort of implied? Yes. And when I was recently in Arizona, I had someone say something similar about Native Americans, like, oh, it's Native Americans here that the racists don't like. You're good for the most part. I'm like, wow, the hierarchy of racism. Yeah. So one question I have about Shelby versus Holder, do you think that ruling is a form of voter suppression itself, or does it grease the wheel for other potential tactics of voter suppression?
Yeah, I mean, I think it's both. I think it's part of a trajectory from the Supreme Court over the last couple of decades that has backed away from the federal government supporting voting rights for especially racial and ethnic minorities around the country, but for all Americans. And there are some really strong corollaries between what's happening now and what happened at the end of Reconstruction in the aftermath of the Civil War, where the 14th and 15th Amendments are passed and there are these really strong constitutional protections, but then the Supreme Court starts by the end of the century backing away from enforcing a lot of those. So whether we think about voter ID laws that have been blessed by the Supreme Court, Shelby County in 2013, of course, Brnovich versus DNC, which occurred a few years later, that was 2021, that really undermined Section 2 of the Voting Rights Act. The Supreme Court, it's not actively suppressing votes, but it is definitely undermining the federal protections that have been the bedrock of increased participation in a more flourishing multiracial democracy. And we know that states are taking advantage of these looser rules, like we were just talking about with Texas passing that bill, but a bunch of states around the country that used to be covered under Section 5 of the Voting Rights Act have enacted restrictive voting policies over the past decade that they frankly would not have been able to. So it's both part of a long federal project or, part of conservative courts trying to back away from federal protections, but also very specifically allowed for new voter restrictions and voter suppression to go into effect.
Well, and that is one of the reasons why I think it's so important in this season's podcast to examine this whole issue as we are coming upon yet another contentious presidential election. Yeah. And I'm just reminded of when you read about voting and the history of voting in America, all these tactics that seem so horrible. The poll tax, the grandfather clause, all of those things that just seem so outrageous, but yet it seems as if there are more sophisticated versions of those tactics. What are your thoughts on that?
Yeah, I mean, I think there is that. There is more sophisticated stuff going on, but there's also kind of old-fashioned stuff in terms of closing polling places and moving them so that they're less accessible. It's things like this didn't end up going into the Georgia bill in 2021, but originally they tried to end Sunday voting, which of course is a big day of voting for the Black church, for mobilizing folks to get out. So yes, there is some sophistication in terms of understanding that if we implement a voter ID bill that might shave 1 or 2 percentage points off of turnout, specifically for people that are going to support opposite candidates, there's definitely a lot of that going on. But there's also, frankly, just old school tactics for making it harder for some folks to vote that would have been blocked under Section 5. But are also part of the story here is a lack of kind of the decline of local media being able to cover these stories when a county in West Texas implements a restrictive voting policy or changes the number of polling places that are open. We have fewer resources to identify where these things are going into place. Which again, I don't mean to take everything back to preclearance in Section 5, but one of the real benefits of having to have every change pre-cleared by the federal government meant that it wasn't up to advocates and civil rights groups to identify and sue and block these things. Everything, whether it was in a place with strong, robust local media or not, had to go up before the federal government and get approved.
But it doesn't seem as if you're overstating it to me. I mean, think about it. We live in a time now where you can't just fly by walking onto a plane. You can't just get out of your car, have somebody drop you off in front of the airport, walk in the airport, get on a plane, like we've done in my adult lifetime. Because isn't making people have to take their shoes off, not take more than a certain amount of ounces, isn't that pre-clearance, so to speak, to prevent something bad from happening?
Yeah, it is. I mean, what's tricky about that particular example is that proponents of voter ID laws would say, you're exactly right. You can't get on a plane without a photo ID from from your state government, which, yes, pre-clearance, like preventative safety measures, especially in places that have been known, that have a history of doing this, to me, it's just common sense. Especially when we're talking about something so fundamental to American life as multiracial democracy is, or we claim that it is, and that it definitely should be. We should, when John Roberts wrote the opinion in Shelby County striking down the preclearance coverage formula, and we can talk more specifically about kind of that and how that actually opens up an avenue for restoring preclearance later if we want. But he said, these are extraordinary measures. The preclearance is an extraordinary measure, very strong medicine, which of course it is and is required when the history of the United States falls so far short of its stated ideals when it comes to incorporating voters of color into the political process.
So if I recall, something in your paper said that the turnout gap grew almost twice as quickly in formerly covered jurisdictions as in other parts of the country that were very similar in their demographics. What do you think that says? What do you think that's about?
Yeah, I mean, I think it's it's an important finding, of course. But I wrote it, so we knew that, there are a lot of things that structure the racial turnout gap. Of course, everyone knows this. And especially for Black Americans, turnout was super duper high in 2008 and 2012 with Obama on the ballot. Political scientists have known for a very long time that having Black candidates, we call them co-ethnic candidates, but candidates of a race are more likely to mobilize voters of that race. So
I'm sorry, they call it what do they call that again?
Co-ethnic mobilization. That's the science term, yeah.
Yeah, the fancy term is there's more than white people running for office. Yeah. Gotcha.
Right. So when there's a Latino candidate, Latino turnout goes up. When there's a Black candidate, Black turnout goes up. So there was good reason to think that when Obama was no longer president, that the turnout gap would grow a little bit. And in fact, this is part of John Roberts in the Supreme Court in 2013, looking specifically at 2012 turnout gaps and saying the turnout gap has closed, was a pretty narrow read of the data because there were specific things pushing the turnout gap down in 2012. But so we always knew that probably the turnout gap was going to grow a little bit, unrelated to voter suppression, when Obama was no longer on the ballot. And so one of the strategies that we use for inferring the causal relationship between Shelby County and the turnout gap is to allow for, say, how much do we think the turnout gap would have grown if Shelby County hadn't been handed down? And then how much did it actually grow? And that's where we get to that. It grew twice as quickly. Not that it wouldn't have grown if Shelby County hadn't been handed down, but that it grew twice as much as we think it would have. So part of this, again, going back to those statewide policies that we were talking about before, some of this is definitely state-level policies like voter ID laws and voter purge practices and things like that. But we also find specifically, even within these states, that it's counties that proposed a change to their voting policy before 2013 and were blocked by preclearance. So whether this was a county that said, we want to redraw our school board districts in this way. And the federal government said, can't do that. That's racially discriminatory. Or said, we want to cut the number of hours of early voting in our county. And the federal government said, no, you can't do this under the pre-clearance regime. So what we find is that the effects are even larger in exactly the places that were trying to do things under the pre-clearance regime that were blocked for racially discriminatory practices. So precisely the places that pre-clearance stopped bad things from going into effect is where we find these bigger effects now. So,
and that's the thing too, when people try to act like folks make too much of race and that's a coincidence and X, Y, and Z. But have any of these laws that have changed with no pre-clearance made it easier for people to vote? Have any of these laws expanded the opportunities for people of color and for poor people to vote?
I mean, we've definitely seen in a lot of states that have passed restrictive laws, some of them have also passed expansive laws. We see this especially in 2020 in some of the states that historically had really strict mail voting laws. Like take New York, for instance. So one of the, not all of New York State was covered under the pre-clearance regime, but because part of the state was covered, all statewide policy was also had to be pre-cleared. So prior to 2020 in New York, you had to have an excuse to vote by mail. Otherwise, you had to be there in person. And now those rules have become much, much easier. Some of it you could say that you were just nervous about getting sick from COVID, and that was considered an excuse. But some states, like and New York, has made other voting easier in other ways as well. Some of the states have done some things to make it a little bit easier, but by and large, we're seeing a trend. Kind of, there's two trends happening in the United States right now, where some states are making it easier and easier and easier to vote and passing robust laws like state-level voting rights acts. So like California or New York have their own state-level voting rights act. So really investing and making it easier for everyone to vote, but with special attention to voters of color. And then other parts of the country are making it harder and harder to vote. So we're really on two different paths right now. And you're exactly right that the group of states that are making it harder to vote are, by and large, states that were covered under Section 5 of the Voting Rights Act.
Yeah, the states that historically have the worst record for a whole lot of things. I've looked at a map of the historical lynching that took place. And it's just interesting to see that those red pins of where reported lynchings take place, unfortunately, has a correlation with states that seem to want to restrict voting. And I know that that's a pretty, harsh thing to say, but you're a scientist. You understand what I'm saying.
Yeah. No, I think these things run deep, right? This kind of fear of democracy, frankly, is what it is. Fear of everyone getting a say in how a local community or a state is organized. It is long. It has long historical precedents, and yeah, there are real definite historical continuities between what was going on in 1700s and 1800s and last century and now. It's all very tied together.
We're going to take a quick break, and we'll be right back with more from Dr. Kevin Morris. This is Race Unwrapped. Welcome back to Race Unwrapped. Today, we're talking to Dr. Kevin Morris about how Shelby County v. Holder affected Black voters. I think this is also in your study that in 2020, just our last, presidential election, that if the gap had not existed, 9 million more ballots would have been cast, and Biden won by just 7 million. In the national popular vote. So, 9 million is a lot of people who didn't have reasonable path to vote, for lack of a better way of putting it.
Yeah, no, you're exactly right. And then we estimate that in the 2022 midterm, that number went up to 14 million. So we're talking huge numbers of voters. In the 2020 election, we also argue that the number of ballots that kind of went uncast due to the racial turnout gap was larger than the winning candidate's margin in more than 30 states.
More than 30 states? Wow.
More than 30 states. So some of these are states that Biden won. Some of them are states that Trump won. That's not to imply that any kind of election would have gone the other way. But trying to put that number in terms of the magnitude of that number is that it matters a huge amount in terms of how competitive statewide elections are these days.
Any predictions on how this gap will impact the 2024 presidential election?
Yeah, I mean, there's many things. A lot of this kind of comes down to candidates, right? Candidates making sure, in terms of the kind of voter suppression side of things, is that candidates speaking to these communities and taking their interests and their power seriously. I think we're beginning to see some of this. These community groups being organized and showing their power and showing, frankly, their electoral power is definitely a big piece of it. Kind of on the voter suppression side, we need to restore the Voting Rights Act. We need to get the voting rights, the pre-clearance formula, the pre-clearance regime of the Voting Rights Act restored. Right now, the truth of the matter is that we don't have a pro-democracy trifecta in Washington, D.C., but a lot of work is being done right now. The Senate reintroduced the Voting Rights Advancement Act, which would restore the pre-clearance condition.
I was going to ask you, is there any chance at all that it can be restored?
Yeah. So I'll finish that. The point just being that, it's hard for individuals to, make the argument that, or be able to influence national policy. But to the extent that people do, live in states with senators that support the Voting Rights Advancement Act, making sure this is a top priority going into next year, if there is a pro-democracy trifecta that comes out of this fall. But yes, there is a way to restore the Voting Rights Act. So what Shelby County did is it didn't actually say that pre-clearance as a concept was unconstitutional. What it said is that there's a formula, and this was in Section 4B of the Voting Rights Act, but Section 4B of the Voting Rights Act contained a formula that said these are the places that are covered under pre-clearance, and these are the places that are not. And what the Supreme Court did is it struck down that coverage formula, and it said this way of deciding what places are and are not covered is not constitutional. So the John R. Lewis Voting Rights Advancement Act would change the pre-clearance condition, the formula, excuse me. It would change which places, and a lot of the same places would still be covered under the pre-clearance condition. But it updates the formula used to determine which places would be covered under Section 5. So there is definitely a way that pre-clearance as an idea has not been deemed unconstitutional by the Supreme Court. And so, yes, this bill that people are talking about, and maybe you and your listeners have heard about, but it's the John R. Lewis Voting Rights Advancement Act, which came very close to passing, by the way, in 2022. It was with the filibuster debate that year when Joe Manchin and Kyrsten Sinema didn't support suspending the filibuster, but that's what that fight was all about at that time in January of 2022.
Right. Has there ever been any discussion of making pre-clearance something that applies to all jurisdictions rather than the ones that have had this historical problem with voter suppression?
So there are part of the John R. Lewis Voting Rights Advancement Act, which is a mouthful.
I know it is.
It would contain what are called known practices. So there are some practices that would be covered nationally. And I am not as super duper up to date on kind of the specifics of the bill as I should be, so I don't want to speak out of school. But there are some policies that would be required to be pre-cleared no matter where they were going into effect. So some things, I think that maybe redistricting is one of those. But any map that gets redrawn would have to be pre-cleared by the federal government before it could go into effect. While other ones, like polling place configurations maybe, would only have to be pre-cleared if they were in one of these places with a history of race discrimination in their voting policy. So yeah, those known practices would make sure that some things that are especially harmful to voters of color would have to be pre-cleared, even in very permissive, progressive states.
Right. So just really one big sort of overarching question. This is my last question. And it's what I really want this season's podcast to do is not just talk about these tactics, not talk about the history and the policies, but talk about how we can be solution oriented. I mean, regardless of what party you support, people should have an easy path to voting. What do you think people should be keeping an eye on, and as we're riding this train bullet fast towards November?
Yeah, I think everyone should be paying a lot of attention to the candidates that are running to represent them. And that's true. You can be a Democrat, a Republican, an independent. We know that in 2022, there were a bunch of folks running for office that were election deniers that said that Joe Biden actually lost the 2020 election. Those election deniers did not do very well in 2022, because a lot of Republicans said, I don't want to support an election denier. So you can be a conservative American. You can be a Republican and independent. It doesn't matter what your party affiliation is. Democracy should not be a partisan issue. So regardless of where you fall on other issues, you should be paying attention to whether or not the candidates that are running to represent you are representing your beliefs about whether or not we should have democracy in the United States and whether or not we should trust the professionals that are running our elections around the country. And frankly, that might mean that some people have to make some tough decisions, that a candidate that they like otherwise has bad views about elections and making democracy available to everybody. And, I study this stuff for a living. I think voting and elections are the most important thing in the world. And I would just encourage your listeners to prioritize that when they're thinking about their candidates and be willing to sometimes maybe sacrifice policy goals if it means really making sure that our democracy remains strong and continues to improve.
And it seems like these days it's hard to say that because everybody wants to be, completely right on everything, and they want you to be completely right. And if there's any talk of compromise or what you just said, which I'm with you, I think that that's what you have to do to get to the bigger issue of democracy. But it'll be interesting to see what happens. It will be very interesting. Are there any other things you think that people should know about or consider in light of the fact that we have this racial voting gap and in light of the fact that the Supreme Court is constantly coming down with decisions that change the trajectory of voting?
Yeah. I mean, it definitely points to the need for strong state level candidates, right? So making sure that you're plugging into local politics and state politics. And, we all, taking a lot of national news, but paying attention to who's running to represent people in their state capitals and what their policies are. Because frankly, at this point right now, we can't really rely on the federal government or especially the Supreme Court to protect these rights. But states do have a lot of power to protect voting rights for their own citizens. So plugging into that. The other thing that I would say is as people are sharing information on social media and posting on Facebook and things like that, making sure that the information that you're sharing, regardless of where you fall on the partisan spectrum, is correct, because the misinformation is really at a very high level right now. And we need everyone to be working with real facts rather than again, things can come from the left or the right. It doesn't really matter where you are on the spectrum, but sharing misinformation is a sure way to increase people's distrust in the system.
That was Dr. Kevin Morris. He's a senior research fellow and voting policy scholar at the Brennan Center for Justice, a nonpartisan law and policy organization. Next time, we'll talk with Karen Short from the National League of Women Voters about their efforts to even the playing field for all voters. I'm Michelle Tyreen Johnson, and this is Race Unwrapped.
Race Unwrapped is produced by Michelle Tyreen Johnson for Louisville Public Media. Alex Biscardi is our audio engineer. Music by Allison Cross. Our executive producer is Laura Ellis. For more information, to contact us, or to support Race Unwrapped, visit raceunwrapped.org.